Welcome back. We are doing yet another episode of the Record Shepherds. What's up, Jason?
All good, Tim. All good. Good to be back.
Good to be back. Feels like we live here now.
Yeah.
At least you do.
Yeah, pretty much.
Yeah. How was your weekend?
Great. I mean, the weather, that's the best weekend of weather we've had for a long time. That's like, before it gets hot and humid and sticky and you don't even want to be outside. It's just like a bit of a breeze in the air. It's still fresh, but the sun's out.
Yeah. It's definitely a good medium. No hot stickiness in New York yet, but when the trash burns and the smells start to come out, you definitely know you're in New York City. So.
Oh yeah, Jesus. I know someone who grew up here but lives in LA now, and they describe like actually missing that smell of like the hot summer trash on the sidewalk, all the garbage. Like, absolutely not.
Nice. Yeah, well, I mean, I have a backyard now, which is amazing.
Yeah, I was about to say, how's your weekend? You've moved into your new place, still getting unpacked, or?
Nah, we're pretty much unpacked. I bought a grill. I made a little Home Depot run. Shout out to the Home Depot in Bed-Stuy. But yeah, I got a little grill, and I was just going to work.
Good.
Yeah, it feels nice. I'm peak dad energy, but I don't have any children, so.
Yeah. So what is it? Is like charcoal or gas?
Charcoal.
Yeah. Authentic.
Got to do it the authentic.
Yeah.
A $6,000 grill is not in my future, but so we'll stick with the nice charcoal one for now. But let's grill some of these music topics.
Oh, there we go. You got the dad jokes anyway.
Yeah, exactly. Right. And I was thinking out loud about how we should cover some recent topics related to copyright and lawsuits within the music industry. It's been a pretty interesting time.
Yeah, it has. On our last episode, we did touch very briefly on the copyright infringement in general, and then the Blurred Lines case, and how we thought that was, we mentioned that a lot of people in the music industry thought that was a pretty precarious, let's say, or dangerous precedent to set for the music industry, specifically for the songwriting community.
Definitely.
And then the next thing I know, turn on or open up my Instagram, and there's Ed Sheeran on the roof of a Volvo playing his guitar to the adoring masses in New York City.
Remember when Michael Jackson won his trial and he was like standing on top of the car? It was kind of
it's similar.
Yeah, exact same scenario. In fact, no,
exact same car, was it?
Yeah, right. And the AI episode was really cool, and we talked a lot about copyright in that, and I think it's important for our audience to know a lot of the protections that they have, not only with AI, because that right now is a bit of an abstract thing for a lot of independent musicians, but this is very, very much relevant to creating music on an everyday basis, and diving into the difference between being inspired and actually ripping from a song completely. So I think this is a good topic.
Yeah, definitely. And I guess like Ed Sheeran, I feel like he's always in the news for this sort of thing. He's always getting accused. He's had two sort of fairly big court cases, this being the bigger of the two, that certainly getting the more press. But he's the first thing that struck me was that he was victorious again.
Right.
So like this is like twice now he's been challenged, and he's had to go through the legal system and through the mill of the courts, and he's come out the other side victorious. And I have to say, I was very impressed at how he conducted himself.
Right.
And then he gave a message. It was a long enough message, like a statement after the victory, and he was humble, I would say, and I just thought it was a fantastically worded and delivered statement. I mean, it should come as no surprise. He's a fantastic songwriter,
right.
So it should be no surprise that it was fantastically worded. But it just was very to the point, direct, and I think it was a strong message behind it. And I thought, you know what, we should do an episode on this.
Definitely. To Ed Sheeran's credit, he's almost an ambassador of the industry, right? He's arguably one of the most successful pop songwriters of all time, which I think makes him a target for a lot of these scenarios. And we're going to talk about how there's been a lot of lawsuits in music, specifically when it comes to copyright infringement over the last 10 years and even forever. But he definitely is a big target when it comes to that.
Absolutely. He's successful, and a lot of people see that success as dollar signs,
right?
And he even alluded to it in his statement. He basically said that a lot of people think they bring these claims, and in his opinion they're without merit, and then basically in the hope that or the sort of knowledge that it's sometimes deemed cheaper just to settle than actually go to trial and go through the expense and the drama and the arduous process of litigation. So he was basically saying the system's broken and something needs to change. And do you know the old adage, like the music industry adage, where there's a hit, there's a writ, and that's basically the reality. People see the dollar signs and they think, if some sort of like similarities or whatever, they go, he's copied my song, and then they think they can shake the piggy bank, basically, get some of the coins out. And
another thing that he said that comes to mind now, and I think he was pretty serious, where he said if he loses this trial, he was going to quit music. He was like, I'm done.
Yeah, I mean, he's been through a lot. Yeah. He's been through a lot over that that period. He had this trial started, or the claim, I think he was saying, was first brought 8 years ago, and then the pandemic probably brought a halt to proceedings, etc. But he referenced that in the statement. He said these trials take a massive toll on people,
right?
And he's just a human. He's not an entity. He's not a big corporation, and he had to spend time over here in New York during the trial, away from his family.
Right.
He's a dad and he's a husband, and during the trial he was not able to attend his own grandmother's funeral in Ireland because he's here. So these trials are arduous and they're draining on people from both sides, he even referenced, and I think he's just probably sick to the back teeth of having been through now 2 of these,
right,
in recent years. So maybe he was serious, maybe he wasn't, but I'm sure he felt like that. He certainly felt like that at times.
Yeah, let's get into the trial, the one that we're going to cover today. I think that obviously, probably from what the listeners can hear, we maybe have a bias in, understanding that this recent lawsuit is pretty baseless in the claims. But I think to your point about how Ed Sheeran carried himself, what we'll read later is how cordial he was with the plaintiff. And I think there's a sense of predatory behavior from either the estates that were also suing him and the lawyers that sort of attached themselves to the children of the songwriter for Let's Get It On.
What you gotta remember is sometimes, especially here in the States, there's a big culture about these lawyers getting their names attached to trials. And it's basically free press and publicity for them and their businesses. So I'm not suggesting that that's what was involved here, but there's sometimes suspicion that lawyers will take cases, etc., for that reason, even if they're not 100% sure they necessarily agree. It could be good publicity,
right?
Good for business,
Right. So what we're talking about is Marvin Gaye's "Let's Get It On" versus Ed Sheeran's "Thinking Out Loud," and there was a bit of misinformation about this trial to the public, where people thought it was the actual Marvin Gaye estate suing Ed Sheeran.
Yeah, that's how it was always reported in the papers, etc. I think it's because Marvin Gaye's estate or Marvin Gaye's name has been in the press a lot, of late. Particularly with the Blurred Lines case, etc. Right. And they very much painted it like, they're back again.
They're back again.
Yeah,
they're pretty infamous and they're back to get more money. But when you do a bit of research and you actually dig into the case, well, what we know is that the original case was filed in 2016, 2017. And like you said, it was delayed by the pandemic, which is why we're now only getting to this resolution. But the original plaintiffs were the children of the co-writer of Let's Get It On. So the actual song, Ed Townsend was the original co-writer of the song, who is no longer alive, but the main plaintiff was his daughter, Catherine Townsend, and also the estates of his ex-wife, Ed Townsend's ex-wife, and the estate of Catherine's sister. So you have lawyers representing the estates of these other two plaintiffs, and then one actual daughter who's the family member of the co-writer.
Got you.
So, not saying that's neither here nor there, but it's to the point that it's not the actual co-songwriter suing Ed Sheeran, nor is it even Marvin Gaye. It's two estates and then a daughter.
Yeah, and I think Catherine Townsend, she made the point, like, she was even satisfied, at the end, even though that they lost. She was satisfied. She seemed satisfied that she'd, done her job, like protected her father's IP. I mean, I'm not sure what I think about that personally, but at least, people who are thinking about possibly copying and not, clearing an interpolation or what have you, they might be dissuaded and thought, like, oh, these people are litigious, because that does happen sometimes. Like, if like a particular estate or a particular rights holder is litigious, then often music companies or other songwriters or whatever won't risk it. They'll get it cleared.
Right. So talking about the case, what was the foundation for the lawsuit? What were the plaintiffs actually saying that Ed Sheeran did wrong?
Basically, it was like the selection and the arrangement of the chords, right? There's only like 12 notes in music,
right?
And which Ed Sheeran reminded the jury of, and basically they acknowledged that while chords themselves are not under protected by copyright law individually, the chord selection and the arrangement of those chords, they were saying that in Marvin Gaye's Let's Get It On, that was basically original and distinctive enough to warrant copyright protection. And essentially Ed Sheeran's side, they defended this and said, like, well, first of all, Ed Sheeran said, like, he hadn't copied like this at all. And because you could go down the route to say that that's not actually protectable under copyright law, but first of all, he said he hadn't copyrighted it, and he basically said, like, these are some of, like, the fundamental, like, chords, and particular, like, chord progressions are commonplace building blocks of pop music,
right,
and indeed in other genres, but these particular chords and progressions commonplace in pop music. And sure, he was even in there with his little guitar.
Well, I was about to say that. So typically when these lawsuits occur, each side sort of hires their own musicologist to analyze the actual sheet music and talk to you about how the melodies or the lyrics are similar. But this was unique in the sense that Ed Sheeran played a really significant part in defending his own music, where he brought his guitar into the courtroom and was actually playing it and showing the jury, hey, this second chord in this chord progression is actually different from the one that they're accusing me of playing. And even if I did use the same chord progression, it's a chord progression. It's not a melody.
Yeah, it's a chord progression. And he showed them how, like, the differences there were. And then I'm not sure if he did it in this particular trial or it was in the other trial from a couple of years back. But, I think he also demonstrated or took them through how there's lots of songs that revolve around these, like, same chord progressions, and that's just the way pop music goes. It's like, as again, there's only 12 musical notes, and he made the point. I think he said there's 60,000 songs being uploaded to Spotify every day. In his previous trial, like, that might have been the case now then, but it was more like 100,000 now. And he basically said there are going to be coincidences, just because things sound the same, that does not necessarily equate to copying.
Right. And maybe that's a conviction of pop music as a whole rather than like individual artists and songs, you know. And not saying that to say that everything should be original, but like this is how songs are made in today's and yesteryear's pop music, and these have been the building blocks for, you know, since we can remember.
Yeah, exactly. So, you know, like his side ended up saying that if you're trying to establish like basically like originality in something like selection and arrangement, and you do need originality to qualify for copyright protection, that you wouldn't there has to be a very high degree of originality for something so fundamental as just basic like chord selection and arrangement.
Right.
So, and that was actually from a prior case, basically, which we sort of get onto, like a Led Zeppelin case, Stairway to Heaven, from a while back. So, like, I mean, the jury ultimately decided in favor of Ed, and you know, they got it from his point of view that no, like, there hasn't been any copying, or the standard that would needed to be, you know, achieved for the selection and the arrangement of the chords on Let's Get It On. It wasn't high enough for you know, for that to qualify for copyright protection, and he wasn't in breach. There'd been a lot of I find it interesting because in the build up to this, you know, we were watching some other like YouTube clips and copyright people, and you know, when you hear the two songs played back to back, you definitely go like, oh yeah, these are oh Jesus, yeah, and like, you know, people going, oh, it's not looking good for Ed, right. You know, like he's gonna get you know, the jury are definitely gonna say that he copied. But what you got to understand is like, that's not what copyright infringement is about.
Right,
you know,
it's like a very superficial way to look at it.
Yeah, things can sound the same. It doesn't necessarily mean they've been copied. And it's like, it's all to do with like originality,
right?
You know, it's like, you know, is song A, or the parts of song A that you're claiming are protected by copyrights? You know, are those original enough to actually be protected by copyright?
Yeah.
And then, is song B original enough, or was it actually copied? You know, like, or did it copy like song A, sort of thing? So it's not always the same, but to the lay person who just hears these things, it sounds like, oh, it's like a watertight case, you know, but that's not what they're looking for. And I think the jury did a good job of actually interpreting the law.
And I think that's an important note for like potential songwriters or, you know, listeners of the podcast who are trying to come up with original music, that you shouldn't be creatively deterred if, you know, when you're originally writing songs that they sound similar to other songs, if you've maintained a high level of originality within your compositions, and it's sort of a natural thing to happen, right?
Yeah.
And that, you know, maybe as your songwriting progresses, it'll sound less and less like what you're inspired by. But I think that's creativity. You can't have creativity, you know, without inspiration first. You need to have something to listen to in order to be inspired to make new songs.
Totally. Like, you know, and it's no secret that, and we touched upon this in the last episode, like it's okay to be inspired, and it's no secret that that's how it works. You know, right. People get inspired. You get, you know, you grow up listening to music, and you know, you have your favorites, and then you always hear like in interview questions, artists are like, you know, like who are your influences? You know, everyone's influenced. You know, and it's okay to be influenced. It's just, there's a difference between being influenced or inspired and then outright plagiarism,
right?
You know, where you're just like literally copying someone.
Yeah. But you know, this case was definitely a sigh of relief, not only for Ed Sheeran fans, but also for the music industry as a whole, I think, because there was a lot of nervousness built up by the precedent that was set by the Blurred Lines versus Gotta Give It Up case.
Yeah.
And I think a lot of that nervousness was fueling the public's view, and kind of why that misinformation got out of, it was the Marvin Gaye estate versus Ed Sheeran, when it actually wasn't.
Yeah, exactly. It was the Townsend estate, as we touched upon.
Yeah.
But yeah, the Blurred Lines case, should we talk a little bit about that? Like, and sort of like just where, because I think it's interesting to say that like whenever this current Ed Sheeran trial, or the one that's just been decided upon, whenever that was first filed, let's say, the law was still up in the air on the blurred lines case. That took a long time to go through the courts, and obviously it went to appeal, and then they were kind of waiting on the clock to run, like, are they going to try to file to take it to the Supreme Court?
Right.
They didn't in the end. Like, they not ran out of time, but they allowed the clock to lapse, sort of thing. So but that was only finally settled during the course of this Ed Sheeran trial. So when it was filed, like, maybe they've been thinking,
right.
Yeah, let's go on, because that was the Marvin Gaye estate. Like,
right.
obviously there's a connection there,
of course.
So people are like thinking about it. And yeah, like that one, the original ruling was 2015, but it was upheld by the Ninth Circuit in the US in 2018.
Yeah, and then the Ed Sheeran case was filed in 2017.
Yeah.
So it's definitely right around the same time.
Yeah, it was like a hot moment there for the minute, like for all these like estates basically to be jumping on, and again, like maybe it's driven by the lawyers, who knows, but yeah, with all the media attention that the blurred lines case got, and the column inches, then yeah, maybe there was some sort of like impetus to sort of have a go.
Yeah. So like that original case with the blurred lines versus Gotta Give It Up, so the estate gives an infringement notice to Pharrell Williams, Robin Thicke, and T.I. In 2013, and then they take it to court. They end up losing. It wraps up in 2018. What's interesting to me is the actual law that Gotta Give It Up is protected under, and it has to do with the date that it was released. Originally, the song came out the 1st of January in 1978. Before that date, though, there was something called the 1909 U.S. Copyright Act, which was in force at the time that the song was composed. And under that act, songs were not protected like they were today. You actually had to submit a deposit copy of the sheet music of your song that was used as the basis to protect that song. And so when this song was taken to trial years later versus Blurred Lines, that was the example that they used to compare the Robin Thicke and Pharrell Williams song to. Yeah,
that's right. Like they didn't actually play the sound recording,
right? Which is another misconception.
Yeah, exactly. So you had to go, because you're talking about, again, like for those of you who are keeping up with the episodes of the Record Shepherds, you'll know by this stage the difference between the copyright in the recording and copyright in the composition, i.e. the song itself. And this is what we're talking about here when we enter this domain of like the chords and the melody and the structure and everything, the lyrics, right? That's very much in the composition side. So yeah, under the 1909 Copyright Act, you're only afforded protection of the sheet music you actually file, whatever the composition is as determined by that sheet music.
Right. Which I think
that's what's actually given the protection. So you don't have the opportunity of playing the sound recording, to actually let people hear it. So you have to sort of demonstrate the similarities and how the actual music has been infringed, the sheet music has been infringed. And the original deposit copy of Gotta Give It Up was described as skeletal, which makes it, I think, to me, even more egregious that the Gaye estate ended up winning this trial, because if you actually read the case, there's the plaintiff, they bring up a lot of examples of things that you can hear in the sound recording but are not actually in the sheet music. Things like bass lines, cowbell, vocal background. These are things that are not on the sheet music, but things that they cite as being infringed upon by. Yeah, you're definitely not going to have the backing vocals and the sheet music, I wouldn't have thought. So, that's strange that they, were able to go down that. That's all like sort of like, in that context, it sounds like smoke and mirrors,
of course.
But there was like a smoking gun there was a smoking gun in that like Blurred Lines case, and it was Robin Thicke had actually gone on record.
Yeah.
Like just to say that I feel like just as a side note, Robin Thicke he had like, you know, his life went like a total high,
right,
very closely followed by a total low,
which
as a result of all of this.
Which is interesting to me, because I do feel like, especially press wise, he bore the brunt of this, and Pharrell Williams has sort of managed to just continue to stay relevant.
Yeah.
And I think Pharrell Williams had a bigger split songwriter wise on the record than Robin Thicke did, but
right, yeah,
for some reason Robin Thicke has sort of faded into the background and Pharrell has still remained relevant.
Yeah. I mean, he was I think he basically started to really believe his own hype for a while there. Yeah. But there's a whole load of things. Just there's I think it was more than just this, to be honest with you. But anyway, there was a smoking gun because he'd gone on the record in an interview. I think it was GQ magazine, and you know, at this stage before any of this legal trouble had started, and he basically said he'd been in the studio with Pharrell. And he said that one of his favourite songs of all time was none other than Marvin Gaye's "Got to Give It Up," and he was like, "Damn, we should make something like that, you know, something with that groove." So then the Marvin Gaye estate come along and say, like, he admitted it. He said that's exactly what they were. He said he was gonna, in their opinion, like copy "Got to Give It Up." And of course, like it's certainly inspired, and there are similarities. There's no question. Yeah, there are similarities, but in the end, like in the Ninth Circuit judge, there was it was decided. They upheld the verdict of the district court at the original trial, but there was one dissenting judge, right?
At the Ninth Circuit.
Yeah, the Ninth Circuit, and they basically said that this ruling has allows the Gays to accomplish what no one has done before, and that is copyright or ownership of a musical style. And that basically, if you can own a musical style, you can essentially own a musical genre. And she said that struck a devastating blow for songwriters everywhere, which I have to say I personally agree with. I think it is definitely a demonstrating brew. I think it was pretty. And there's a lot of attorneys in the music industry, the music and entertainment space, who would agree that was not a great outcome for the songwriting community. And it took copyright into new territories that we'd never been before, and probably as a creative community wouldn't necessarily want to be in. So to me, just to bring this back to like listeners and even some bands, I think this is why it's important to really have, you know, your songwriting splits, you know, down packed before you go into a studio and you record a song. Because as an instrumentalist, as a drummer, I'm thinking, you know, you can't copyright a groove. You can't copyright a style. But I empathize with the emotional feeling of, if I played a nice groove or a bass line on this record, as an instrumentalist, I should have some protections as well, right? But, you know, unfortunately, if you're not a songwriter in this case, there's not that many protections that you're afforded. Yeah.
But if you're, but if you're in a band and like you really feel like your contributions were significant enough to take that song and elevate it and bring it to another level, then maybe a songwriting split should be in the conversation between you and your band members. You know, but it's debatable, right? Because if I'm the sole actual songwriter in that band, I'm writing the melodies and the lyrics, then, you know, I don't technically have to give you that split. But hopefully you have a good relationship with your bandmates or your group mates and you can have that honest conversation.
Yeah, totally. But it's difficult because, like, you know, like, what did you really, is that an original groove? Or is that not just an R&B groove or variation of an R&B groove that's existed, you know? And back to the Sheeran case, like, he had said, like, look, these chord progressions, these were already around long before Marvin Gaye's song, Thinking Out Loud. Yeah. Was written, you know, so this is not like original to Marvin Gaye. They've been around, they're going to be around, and everyone should be free to use them.
Yeah.
You know, it's like in the same way he referred to like no one owns the color blue.
Right.
You know, it's like every artist, like the colors should be available to every artist, just what you paint with them.
Yeah.
You know?
The only thing I would say that was against Ed Sheeran talking about smoking guns, because
smoking gun.
I want to parallel the Robin Thicke interview with the fact that Ed Sheeran would play a mashup of Thinking Out Loud and Let's Get It On Live. And there's an actual video out there that a fan recorded on a European tour where he would go back and forth, and that seems a little.
I think that's what probably spurred the Ed Townsend to stay it on and said like he even knows it. He knows it sounds similar. Like it's sort of again, it's like an admission.
Yeah.
But I just go back to that point. Just because something sounds the same,
right,
does not mean that it's a copyright infringement. You know.
Yeah.
So it's just like, and there are lots of songs, you know, that he could have done that with, and I think he gave an example in one of his court cases of going from a Beatles song to some other song and then back to another Beatles song. You know, it's just those are the building blocks of pop music. You know.
Yeah.
So.
But there was another court case, because I talked about the anxiety that the Marvin Gaye, Robin Thicke, Pharrell Williams verdict gave to the music industry. But we are in our pre-production we were talking about the Led Zeppelin case as well.
Yeah.
And how that sort of alleviated some of the concerns that the music industry had. Yeah,
it did. It sort of like brought things that was after the Blurred Lines case, and as I say, that left everyone thinking like we're in a pretty dangerous place now in terms of creativity and encouraging new creativity and new songs and up and coming songwriters, all that stuff. But thankfully there was a later case involving Led Zeppelin, specifically their mega hit Stairway to Heaven.
Yeah,
it is a mega
understatement. Yeah.
And that was, again, there was like some sort of like proximity, like to prove copyright. One of the things you have to actually establish in helping demonstrate there has been copying is what's called access. You have to have access or have had access to the original work, and that basically means like the opportunity for hearing it. Right, and this was involving another trustee of the songs of Randy Wolf, whose band Spirit had played alongside Zeppelin back in their early days. I think they'd been on a few bills, the same bills, etc. And they had a song that was released a few years prior to Stairway to Heaven. I think it was called Torres, and it had this same chord progression and arpeggiatic, chromatic something or other, basically. And it was just that stepped, that stepped intro of everyone like who's familiar with like
yeah, exactly. It's basically just taking a chord and deconstructing it and playing the notes individually, like up and down.
Yeah,
Yeah.
So
and people misinterpret that as a melody, but
so. That's what it was. It was a similar thing, like on a similar like bass line, resembling Stairway to Heaven. But the Ninth Circuit Court basically established that they sort of brought things back to like a sort of like a better place for copyright, essentially, and copyright laws as far as the songwriting community goes. And again, this was one that was like, they said, look, there's commonplace building blocks in songwriting, and there are only like 12 notes, and there are only so many things that we can do with these notes. And these commonplace building blocks, if you're trying to establish copyright protection and basically, like some sort of like ownership or copyright protection for these commonplace building blocks, the threshold of originality has to be a lot higher, basically. And so they established these like couple of tests. One was called the extrinsic test and one was the intrinsic test. the first one basically would involve experts like musicologists, like being able to establish was there similarity, and then the second one is, do they sound similar just to the reasonable person sort of thing. So in that case they didn't even need to get onto the second one because the first one fell away. And the upshot was that it pulled things back a little bit from the precipice that was the outcome of the Blurred Lines case. So it seems that we're going in the right direction, with these things, if Blurred Lines was sort of considered controversial and, not a great place to leave us in as far as the songwriting community and creativity goes, then the Led Zepp case and these latest two Ed Sheeran cases have really brought it back a little bit.
Yeah. What's interesting, though, is that the Supreme Court has not heard a music copyright case in a long time. There hasn't been too many.
Yeah.
And doing a quick research, there was a John Fogerty Creedence Clearwater case, and then there was the Two Live Crew one that we were talking about as well. But those were a bit different than what we're talking about
that
today.
Two Live Crew was to do with like that basically demonstrated that you could parody was a legitimate defense to copyright infringement. But going way back, the someone who did run a ground on copyright infringement was George Harrison and his "My Sweet Lord" track, and he lost a trial, and he basically, I think he was quoted as saying like it forever from that point onwards he became a very paranoid songwriter, because in his mind the sort of whole crux of that was like, going back to access, that the law in that case basically that was laid down was that if you had there could be subconscious copying. So even if you you don't have to actively set out to copy something, you could just be aware of that song. If you'd heard that before, if it was in your sort of world at some point in time, the Harrison case basically established that was enough to constitute access. You didn't have to actively intend to copy it. It could have just been like subconscious copying. So George Harrison was very paranoid as a songwriter from that moment on. And actually, the third thing or the second thing in the Led Zepp case, the Ninth Circuit Court basically overruled itself on that point. It basically there used to be essentially in a nutshell they said, look, music is ubiquitous nowadays. It's everywhere.
Right.
So essentially that rule about, like if you've had access to it,
the likelihood of you not having access is more unlikely than you having access.
Yes, yeah. And the sort of inverse ratio that was established in the George Harrison cases, like if it's been shown that you had access, or the higher degree of your access, then the proof of similarity, that level dropped a little bit, so you didn't have to prove the same high degree of similarity or whatever. So they basically did away with that in the Led Zepp case. They sort of took that opportunity. They said, look, there's a lot of other circuits in the United States have sort of like moved away from that, and we're going to take this opportunity to sort of overrule ourselves on that point. So again, I think it's moving in the right direction for songwriters and the creative community in that way. And it's like, to Ed Sheeran's point, he thinks that even still the system is broken, with people being able to just like file these what he views as baseless claims,
right,
and suck up time, energy, money,
right.
And he was thankful that the outcome went the same way, but he's basically said, look, system's broken, and but maybe the more cases that are decided, this way, that no, there hasn't been an infringement here, then the less likely people are to, bring these same cases and risk incurring lots of legal fees themselves and having to pay the other side's legal fees.
Do you believe that there should be another Supreme Court look at some of these music copyright cases?
I mean, it's certainly established here in the US. It would establish like some clearer guidelines in 2023 or for the years ahead, because just like every now and then you do need like sort of like to set the scene of where do we lie in this day and age, sort of thing. But it's it's not always, you don't always get that wish, the legal, it's super expensive to go that far for a party, and in the end sometimes there's two courts that by that time you've got that stage have made their decision and given you the rationale and the reasoning, and often you're just racking up fees, the other side are racking up fees, and if you're going to have to pick up the check, it's you got to have pretty deep pockets and like real conviction to even go to that far. And then sometimes the Supreme Court just won't even hear it. They take a look at it and say, no, it's like there's nothing to be decided upon here. We don't see any issue with the law that's been applied or the interpretation of the appeals court. Yeah, you almost, to get that to that point, you almost have to provide new information, or else or provide that. There has to be a certain point of law to be decided upon that the plaintiffs or the defendants feel was not correctly what's the word, explored or investigated or decided upon, ruled upon, but we don't need to go there, I think it's sort of like slowly been reined in a little bit, and imagine if I was a songwriter or like an Ed Sheeran or whatever, it'd be bloody annoying. He was expressing real kind of like, he said like it's actually insulting that you think I have to go and copy, I can't just like write my own, like I'm a professional songwriter. Right. That's basically like you saying to me I can't do my job. Right. Maybe he's got to get Robin Thicke on a track, get him some redemption money so he can keep paying the Marvin Gaye estate. Yeah, maybe. I don't know. But I mean, I think that was a good covering. And again, just don't be afraid to create new music because you're inspired by something. I think that's an important takeaway. But then also know what your copyright protections are for your original works. Yeah, and like maybe people are thinking, well, what if I have copied something? What if I actually have copied something? Does that mean like I'm going to get sued or whatever? And it's like, well, if you have copied something, especially if you've like sampled something, when you sample the actual recording, you're obviously sampling the recording, and then by virtue of that, you're also sampling the composition, the actual. So that's. Or you could just not be sampling actually the recording, but just like using the same lyrics or whatever, that's called an interpolation, or the same note progression or whatever, that is actually genuine copying that does amount to like would amount to a copyright infringement. If you're going to do that, then just make sure you go and get a license from the rights owners. Right, so you just let them know that in advance that like, here, this is what I've done, and here's my new work incorporating the old copyrighted original work, and I'd like to get a license, please. And it's going to cost you money, or a royalty, a split of the song, whatever it might be, but. That's worth it, you know, in the end. You don't want to be getting sued. And the other thing is, like, you have to be real. Like, they could say no, and, at our place, sometimes we get requests for, like, sample clearances or whatever, and just for whatever reason, they don't, they want to protect they don't want to dilute the value of the original work, etc., and they say no. And, like, that's their right. That's their right. That's, and then if you come up with your original material, that's your right as well. Like, that's how it works. That's what the copyright's all about. But yeah, like, but definitely if you're going to be releasing commercial music and it's there's samples in it or whatever, just go and get it cleared, and then and get knowledgeable about copyright law. There are some defenses, like there's fair use is a legitimate defense, like parody is a legitimate defense. So that like if just go on the internet and like Google it and get knowledgeable about it, and then just know what's within sort of reasonable parameters and what's not. But yeah, ultimately, I think it's just important to remember that there is a difference between inspiration and plagiarism. So
inspire, don't plagiarize.
Exactly, that's
Be
it.
inspired.
Exactly. I don't know if we have time for it. I'd certainly direct people to go and check it out, but there is an Ed Sheeran statement. I said I'd mention it.
Yeah.
Should I read a little
it.
bit of it out? Yeah. It's reasonably long, but I'll try to read quickly and see where we get to. He basically says, I'm obviously very happy with the outcome of the case. It looks like I'm not having to retire from my day job after all. At the same time, I'm unbelievably frustrated that baseless claims like this are allowed to go to court at all. We spent the last 8 years talking about 2 songs with dramatically different lyrics, melodies, and 4 chords, which are also dramatically or different and used by songwriters every day all over the world. These chords are common building blocks which are used to create music long before Let's Get It On was written, and will be used to make music long after we're all gone. They're in a songwriter's alphabet, our toolkit, and should be there for all of us to use. No one owns them or the way they're played, in the same way no one owns the colour blue. Unfortunately, unfounded claims like this are being fueled by individuals who are offered as music experts in musical analysis. In this instance, the other side's musicologist left out words and notes, presented different and simple pictures as melodies, and by doing so created what I think we've proved for all to see were misleading comparisons and disinformation to find supposed similarities where none exist. And I think we proved for all to see that they tried to manipulate my and Amy's song to try to convince the jury that they had a genuine claim. I'm very grateful the jury saw through those attempts. This seems so dangerous to me, both to potential claimants who may be convinced to bring a bogus claim, as well as those songwriters facing them. It's simply wrong. By stopping this practice, we can also properly support genuine music copyright claims. Legitimate claims are rightly heard and resolved. If the jury had decided this matter the other way, we might as well say goodbye to the creative freedom of songwriters. We need to be able to write our original music and engage in independent creation without worrying at every step of the way that such creativity will be wrongly called into question. Like artists everywhere, Amy and I work to independently create songs which are often based around real life, personal experience. It's devastating to be accused of stealing someone else's song when we've put so much work into our livelihoods. Just another little bit here. I'm just a guy with a guitar who loves writing music for people to enjoy. I am not and will never allow myself to be a piggy bank for someone to shake. Having to be in New York for this trial has meant that I've missed being with my family at my grandmother's funeral in Ireland, and I will never get that time back. And basically it goes on for another paragraph, but he concluded, we need songwriters and the wider community to come together and bring back common sense. These claims need to be stopped so the creative process can carry on and we can all go back to making music. At the same time, we absolutely need trusted individuals, real experts, who help support the process of protecting copyright. Thank you. Solid statement. And he raises a lot of good points in that.
Yeah, definitely. And at the end of the day, people's times are wasted. And not only does it cause harm to songwriters and, for people with legitimate copyright concerns, this sets a bad precedent, right? Because maybe they don't want to bring it to trial now because they see that, this, was ruled against the plaintiff of the family of that songwriter. So, it hurts everybody all around.
It does, yeah. But, I think it sort of gives the message that, as I said earlier, just because two things are similar does not automatically mean copying, you know, and that's probably something for, you know, these other rights holders and estates, etc., to bear in mind.
Right.
You know, like you don't own the building blocks of songs. Mm-hmm.
Be inspired. Don't plagiarize.
Exactly. And you know what it is? That attitude and that freedom will help the Marvin Gayes of tomorrow succeed. Do you know?
Yeah.
Give these songwriters the tools that they need, and we're going to produce more Marvin Gayes, you know.
And listening to the Record Shepherds might produce more Marvin Gayes as well.
Yes.
If you have the wherewithal to pick up the information we're putting down when it comes to copyright, when it comes to all of these things. And hopefully if you listen to us, you won't get sued in the future. And if you do get sued, call Jason, because he will represent you and you will win. And exactly. I'll have your back too.
Yeah, give me that publicity.
Definitely. But thank you guys for tuning in for another episode. We want to encourage you guys to comment and, you know, give us your feedback on the Ed Sheeran Marvin Gaye lawsuit, and tell us what you think. You can email us at therecordshepherds@gmail.com. Again, like, comment, and subscribe, and you can listen to us where all podcasts are streamed. And if you're in the New York area and want to have a conversation about any of this stuff, please feel free to hit us up. We are more than welcome to offer you a spot on the couch.
Yeah, and that leaves it for me to say, until the next exciting episode, continue to follow the guidance of the shepherds.
Don't be the sheep, be the goat.